junior counsel of the appellant Gandhi. My learned counsel has already addressed your lordship in the first round of appeal. So I will now address your lordship in the second round of appeal.
Yes.
My submissions will therefore deal with Mr. Gandhi, whether Mr. Gandhi is entitled to damages because of this misrepresentation. My lord, the following submissions will be in the order that, firstly, Mandela made a false statement of fact, which does in fact constitute a negligent misrepresentation. Secondly, there was a negligent misrepresentation which involves a statement made honestly, but without grounds for reasonable belief. And thirdly, under Section 2, subsection 1 of the Misrepresentation Act 1967, a statement that is made without reasonable grounds to believe that the statement is true is actionable misrepresentation which will make the representative liable. To proceed with my first submission, my lord.
Please, Counsel.
A misrepresentation can be defined as an unambiguous false statement of fact which is addressed to the party misled and which induces the party to enter into a contract. First of all, the misrepresentation must have been unambiguous and clear. In this case, Mandela expressly stated in his advert that the bicycle was a limited edition Roadmaster 2000 odd enough for £500. Secondly, the misrepresentation must have been false. Since we have all been enlightened that all limited edition bikes are red, we can safely assume that this blue bicycle was not in fact a limited edition.
Counsel, my understanding is that's not an issue.
I am obliged. Thirdly, there must have been a statement. There's no doubt that in this case, a statement was made in the form of written communication in the newspaper. Assuming there was a statement, it does not necessarily have to be a term in the contract, and it will suffice that it induced my client, Gandhi, into entering into the contract. In the case of Avon Insurance Limited against Swire Fraser Limited, which can be found in Volume 1 of the All England Reports, year 2000, page 573, which at the bundle, my lord, is page 26 for you.
Yes, thank you.
Rix J declared the test of causation is inducement, that the misrepresentation need not be the sole or decisive inducement as long as it materially contributed to the decision of the representee to enter into the contract, and that a misrepresentation, for instance, one likely to influence a reasonable man, sets up a presumption or inference that the claimant has been induced.
Yes.
In conclusion to my first submission, my lord, Mandela made a false statement of fact. To proceed with my second submission, there was a negligent misrepresentation which involves a statement made honestly, but without grounds for reasonable belief. In the case of Headley Byrne and Co. Limited against Heller Partners, which can be found in the House of Lords Appeal case, page 465, year 1964. In the bundle, my lord, you can find it at page 88.
Yes, I have that. Thank you.
I am obliged. In this case, it was established under common law, where a person who has or professes to have special knowledge or skill gives misleading information with an intention of inducing the other party into entering into a contract, he is under a duty to use reasonable care to make sure the information is correct.
Yes.
From the facts of this case, Mandela maintained that he's not a bike expert and that he genuinely believed the bike to be a limited edition. However, my lord, common sense would dictate that if somebody has been cycling for so many years that they now wish to retire, the evidence would allow us to conclude that they must have acquired a sufficient mental skill or sufficient knowledge to distinguish the difference between a limited edition bike and one which is not.
Counsel,
Yes, ma'am.
on that point, are you saying then that there is no difference that Mr. Mandela is selling a bike in an offhand way in the back of the newspaper rather than selling it over the counter of a bike store? There's no distinction to be drawn there.
My lord, the point I'm trying to make is that the fact that he's been a cyclist for certain amounts of years, even though he doesn't claim to be an avid cyclist, he should still be in a position to at least find out whether he can advertise the bike as a limited
Mr.
edition.
Counsel, in answer to my question, so there's no obligation that he has to be holding himself out as having special knowledge or skill, simply such that he has that special knowledge or skill.
My Lord, can I refer you to the case of Stephen and Rogers? It interpreted section 14, subsection 2 of the Sale of Goods Act.
Yes.
That act, my Lord, establishes that whether a person is acting under normal business transactions or as a individual dealer, the moment he advertises a product for sale, he comes under the commercial transactions. Therefore, he would be obliged to give the correct information.
Yes.
Does that answer your question?
Yes, thank you, Counsel.
I am obliged. This point was re-emphasised by Lord Denning in the case of Esso Petroleum and Marden, which can be found in the Queen's Bench Division, page 801, year 1976, which can be found in your volume, my Lord, under page 135.
Yes, I have that.
I am obliged. In this case, Lord Denning stated that a person is under a duty to use reasonable care to see that the representation is correct and that the advice, information, or opinion is reliable. In this case, it can be assumed that where one party intends to sell a bicycle, they have a duty to give accurate information to any potential buyer who shows an interest. My Lord, moving on to my third submission.
Yes.
It is submitted under Section 2, subsection 1 of the Misrepresentation Act 1967, where a person has entered into a contract after a misrepresentation has been made by him to another party thereto, and as a result thereof he has suffered loss, then if the person making the misrepresentation would be liable to damages, in respect thereof had the misrepresentation been made fraudulently, that a person shall be so liable, notwithstanding that the misrepresentation had been made fraudulently, was not made fraudulently, unless he had reasonable ground to believe, and did believe up to the time of the contract, that the facts represented were true. The respondents may try to argue that the statement was an innocent misrepresentation, as there is no proof of reasonable grounds. However, in this case, there is no evidence which directs us to conclude that Mandela believed his own statement, my Lord. It is a well-known fact that products which are labelled as limited edition tend to hold more value than products which are not. Therefore, it would be within Mandela's best interest to shut his eyes and blindly state that the bike was a limited edition when in fact it was not, my Lord. Mandela's statement was therefore made without reasonable ground for belief, thus holding it to be a negligent misrepresentation. In conclusion, my Lord, if there has been a false statement of fact which was made with no reasonable grounds of its truth, and as a result induced my client to enter into the contract, I would seek your lordship to award my client with the reward of rescission. Would it not be absurd if we allow perpetrators to create alluring adverts to deceive the consumer? The aim of contracts, my Lord, is to protect the vulnerable party, and if there has been a negligent misrepresentation, the aim of the remedy is to put the appellants back in the position in which they would have been in before they entered the contract. Unless I can be of further assistance to you, my Lord, those are my submissions.
No, thank you, Counsel.
And